This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. If you have an immigration problem or you want some advice, then please get in touch with me on any aspect of immigration. In today's video, we're going to be talking about, looking at the court's approach to activities carried out by asylum seekers in the United Kingdom. Let's put it another way. How important is the belief or genuineness of the beliefs in an asylum claim? The reason for this video is that the court have recently been looking into activities carried out by asylum seekers in the United Kingdom, which are in legal terms referred to as surplus claims. This video and the guidance from the Court of Appeal is particularly important as many people who have fled their home country are often politically active in the UK, often more politically active in the UK because they're freer. And the question has always been, does this put them at risk if returned to their home country? So what I would say at the outset is that if you're thinking of making an application for asylum based on activities in the United Kingdom, or have made an application and you're carrying out with your activities in the United Kingdom, or you just want some help in an asylum claim generally, then get in touch and I'll do my best to advise you. Recent case law has looked into the issue of whether asylum seekers who attend political demonstrations in the United Kingdom, as many do, need to be genuinely committed to the cause that they are allegedly supporting. So the question is, that you're at a rally and the photographs, etc., do you need to have genuine beliefs? In short, when the Court of Appeal considered this, they have said that it's not the genuineness of the belief that's important, but whether the activity itself will put the person at risk. This is an important distinction. The background to this is that it has long been the case that activities that take place once a person has got into the United Kingdom must be taken into account when considering an asylum claim. The issue was whether the beliefs were genuine or not, and this was considered by the Court of Appeal. A person who regularly protests outside the embassy of the country they are fleeing will usually be more at risk than someone who comes to the United Kingdom and keeps their head down. That's common sense. But does the asylum seeker attending these demonstrations really need to believe in the cause that they are protesting about? That was the issue the Court of Appeal had to decide. And they recently revisited this issue in a case called SR Sri Lanka. In that case, SR had attended numerous Tamil protests in the United Kingdom. His application was refused, and the first tier judge said that his actions were self-serving and not motivated by a genuine commitment to the Tamil cause, i.e. he was just going to the rallies to help his claim. SR then argued that the first tier tribunal had been wrong to attest whether his commitment was genuine. It was said on his behalf that his activities would place him at risk if returned to Sri Lanka. He argued he would be questioned by the authorities, and whether or not he was genuinely a supporter was irrelevant. Although the decision was upheld overall, the Court of Appeal did state, most importantly, that had there only been one issue in the case, which is would the activities put the person at risk, then the appeal ought to have succeeded. It was confirmed that even if a person's political demonstrations taken opportunistically and without genuinely holding political beliefs, they may still put someone at risk because of the perceived beliefs by the receiving state. What the Court of Appeal said was extremely relevant, and it said whether or not the returning country will care about the activities or believe the beliefs that are genuinely held is more or less irrelevant. In SR, the Court of Appeal stated that if a person's political demonstrations will not be taken seriously by the Sri Lankan authorities, they do not qualify for protection. So in summary, SR confirms that surplus activities are relevant to a claim, even if the person doesn't really believe in the cause. However, if the country doesn't believe that the beliefs are genuine or doesn't care, they will not be eligible for refugee status. So it depends to some degree, not so much on whether one is attending the demonstrations, but on whether the receiving country or the country from which the person has fled takes a dim view of people protesting against their regime. So cases will tend to be country dependent as well as fact dependent, and the person will need to show a fair degree of activity. But it's an important decision, and says, again, going back to whether someone's at risk or not, the question is a very simple one. Are they at risk or are they not at risk? Rather than whether they have any genuine belief either in the country of origin or in the United Kingdom. I hope this video has been of some use in clarifying what the Court of Appeal has said about activities in the United Kingdom or surplus claims. If you have any questions or doubts about it, or you're involved in the asylum process, or you're thinking of making a claim, or you have made a claim, or you have been attending rallies, then if you're not happy with your representatives or you want to get a second opinion, get in touch with me and I'll do my best to help you. Once again, thank you for watching this video. I hope it's been interesting. It is extremely important, and I thank you for taking the time to watch me and me expressing my views. Do stay safe. This is Paul Turner, the Immigration Barrister at Imperium Chambers.